So now, you know, when I was growing up in the 80s and 90s, when one heard the Ghana Bar Association mentioned, you immediately were compelled to accord them enormous respect because of the personalities who featured prominently in their leadership and the way that they conducted themselves. Well, even if you could associate them with some political traditions, you had no option than to acknowledge that these were people who were saying things that they believed in and were acting as the voice of society. You know, at the time, we were under military rule, and therefore the space for free expression was a bit constrained. So organizations like the GBA, the Catholic Bishops Conference, the Ghana General Association, to which Mr. Pratt belonged, and others, served as the counterbalance to government. And it was understandable because of the climate. I mean, when the likes of Mr. Peter Lajete of blessed memory, Mr. Dorocha Yonko ruled the roost in the GBA, they came with some significant respectability. Disagree with the issues that you raised, but you cannot take away the fact that they represented something significant. So in the time that the NDC was in power, they regularly commented on socio-political developments, they championed human rights, and were quick to analyze government policy and call a spade, as it were. Then came the change of government in the year 2000. A few years down the line, I believe it was 2004 or 2005, if I'm not mistaken, an astonishing position was adopted by the Ghana Bar Association. And I'm sure Mr. Pratt and others on the panel remember it. They said that because there had been a change in government, we were no longer going to comment on socio-political developments in the country, because they had absolute faith in the new Patriotic Party government to safeguard those. So they publicly relinquished their role as an important voice in society. Since that day, I have personally written of the Ghana Bar Association as a credible organization whose voice matters in national discourse, because they clearly showed that they were partisan and that all the things they had been doing was not geared towards championing the rights of the Ghanaian and ensuring that governments do not overreach and engage in activity that impinge negatively on the citizenry. And that it has appeared that that whole setup was aimed at pushing the agenda of the new Patriotic Party. And we know that there were serious human rights violations under the NPP between 2001 and 2008. Indeed, the most notable amongst them was the brutal murder of Issa Mobila in military custody in the immediate aftermath of the 2004 elections. Indeed, the pictures of Mr. Mobila's mutilated body was splashed on some newspaper front pages, and it made for gory reading. This happened, and not a whimper was heard from the Ghana Bar Association. I recall the arrest of was it the Shushan boy who criticized President Kufuor's frequent travels. He was immediately abducted by state security agents and kept unlawfully. The Ghana Bar Association was silent on that matter, and many other things that they did. Indeed, the biggest evidence yet that the Ghana Bar Association had clearly exposed themselves as being tied to the apron strings of the new Patriotic Party emerged when Mr. Sajuti Carter was imprisoned in the middle of 2008. Now let me give you two scenarios. Now in the I think it's the early 90s or late 80s. Mr. Pratt perhaps may have a better memory of those proceedings. You recall Mr. Mensa Bonsu, who wrote a scathing article about Justice Aban over some ruling of the Supreme Court. Now, Justice Aban and the Supreme Court felt that that publication was contemptuous of the Supreme Court. So they in fact held him in contempt and imprisoned him for about a month, if I'm not mistaken. Do you know that the Ghana Bar Association asked all lawyers in Ghana to go on strike and boycott court proceedings in solidarity with Mr. Mensah Bonsu for making comments that the Supreme Court deemed contemptuous, and for which reason they had held him in contempt and imprisoned him. So for as long as Mr. Mensah Bonsu suffered that penalty, members of the Ghana Bar Association were unprepared to render legal services to the people of Ghana in solidarity. I can understand the principle of that. So here is a member of the yes who had suffered some consequence for expressing his view about the ruling of the Supreme Court. So they went on strike. Eventually the strike was resolved, and I'm sure some resolution was found to that matter. Then send a fast forward to 2008. Sometime in June, Mr. Chikata was unceremoniously bundled into prison by Justice Henrietta Aban in the middle of the case, when no indication had been given that judgment was going to be given. So we were here one afternoon when you said that Mr. Chikata had been jailed for allegedly causing financial loss to the state. So you know the Free Chachu movement sprang up. I was a key member of that movement. We agitated across the length and breadth of this country to secure Mr. Chikata's release. Then, at one of the events, Mr. Osamuels, who was the president of the Ghana Bar Association, had cause to comment on what he believed to be the irregular approach of the judge in handing down that sentence to Mr. Chikata midstream, when no clear indication had been given that judgment was anywhere near the corner. For making this comment, Mr. Osamuels was removed as the president of the Ghana Bar Association at a conference in Kumasi because he commented on how a court had handled Mr. Chikata. So here's the same Ghana Bar Association, which under the NDC was prepared to punish the general public by refusing to allow its members to render legal services because a member of DS had suffered some penalty at the hands of the Supreme Court. He had made comments that the court found contemptuous. The same body under the NPP removed their president under the NPP, yes, removed their president because he also went to the aid of Mr. Chikata, who had been unfairly treated by the courts. Now, there's no clearer example of the duplicity and partisanship of the GBA than what I've given you. You see, when the NPP is in power, they tag along, they acquiesce, they allow all manner of wrongdoing on the part of the NPP. Not a whimper is heard from them. But the moment the NDC comes to power, they are up in arms, purporting to be defending the rule of law and constitutionalism. And that is what is at play in this Chief Justice matter. Because I cannot for the life of me understand how the preeminent body of lawyers in this our country can take up positions that essentially calls on the president of the land to violate the 1992 constitution. Because a Chief Justice appointed by an NPP president has been asked to go on suspension pending investigations into allegations made against him in full compliance with the 1992 constitution. When the suspension first took place, the GBA issued a statement which many people hailed as balanced. Indeed, they called for the rule of law to prevail and asked all parties to exercise restraint and respect the constitutional process. So Ghanaians hailed it as a significant departure from their partisan stance in the recent past. Then somehow NPP members, the likes of Dana Sunaba Dapa, Frank Davis, Godfrey Damianko, immediately got other members of the GBA with affiliation to the NPP to insist on an emergency conference. Then 47 out of 5,000 lawyers go and pass a supposed resolution, and then the GBA does a 360-degree turn and calls for the president to violate the constitution and halt the process. When they know that the president does not have such powers. So I have given this background to put the call that they've made recently into proper context. It is a partisan call. Also, the GBA is pushing an exceptionally troublesome narrative. They are advocating for the sacred cow principle, Which means that, Senna, because you are the host of this program and your position is so lofty, when you steal my phone, you should be allowed to walk. But if I go and steal a finger of plantain, because I'm not the host of this program, I should be thrown into jail. That is what the GBA is saying. When was the last time you heard the GBA defending a coconut seller who had been thrown into jail for stealing a goat? Have you heard the GBA? There are several people languishing in Sahum who has been sent there on remand and have been there for years. The GBA has never been interested in going to their aid to ensure that their cases are heard expeditiously. And in some instances where clearly they are not at fault, or even if the offense is minor, the court treats them with leniency. They never do that. Yet, they are saying that the Chief Justice of Ghana holds such a lofty position that even when clear constitutional processes are followed to adjudicate a matter which has been brought to the attention of the president, pursuant to the constitution, and all constitutional processes have been observed to the letter, and no infraction can be pointed to, that action should not be taken because it is the Chief Justice. You see, we can't build a country like that. The fundamental principle of the rule of law is that we are all equal. So as far as the law is concerned, the coconut seller is the same as the Chief Justice. As far as the law is concerned. You see, if you look at the symbol of justice, it is a woman who has a blindfold holding a scale that is balanced and a sword. The blindfold means that she does not see the person before her in terms of coloration or their status in society. The scale means that there is balance. They will treat the coconut seller the same way they treat the Chief Justice. And then the sword means that there will be swift action or retribution if you are found to have broken the law. The GBA is saying that we should cast this symbol aside and do as they please, because the NPP believes that that is what has to be done. In fact, the GBA itself, if you look at their symbol, it is a scale, a pair of scales, right, with a weight over it. What does the scale stand for? Balance. So the same principle applies. The coconut seller is the same as the Chief Justice in the eyes of the law. We should never get to a stage where we countenance this discourse from the GBA that because of the personality involved, action should not be taken, when the Constitution prescribes exactly what has to be done in this process. In fact, the President of the Republic of Ghana is the same as the coconut seller as far as the law is concerned. As I speak to you, South Korea in the last 3 years or so have imprisoned 2 presidents for various offenses. They have imprisoned 2 their nation has not come to a halt. In fact, their country has not collapsed. Nobody can say that South Korea is a banana republic or a country where the rule of law is not respected because of that action. But that sends a signal to everybody that no matter who you are, to the extent that you violate the law, you will be dealt with. Why did the US not impeach Bill Clinton? He was only saved in the Senate, but the House of Representatives impeached him. Did America collapse because of that activity? Was Richard Nixon not removed from office in the wake of the Watergate scandal? Did America collapse? Can we sit here and condemn American democracy and governance and dismiss the rule of law? But in Ghana, we tend to fetishize our courts. We make it seem that the same judges who, through the slamming of a gavel on the table, can sentence you to death. Can sentence, in fact, only 2 days ago, Agrada was handed down a 15-year sentence. It was a judge who did that. Suddenly, the GBA and the NPP create the impression that even mere criticism of a judge will cause them to kill over and die, so we shouldn't do it in this country. The same people, and I'm sure you've been to court a number of times. Judges wield enormous power. They are not anybody's spring chicken. These are tough cookies. People who have the backbone. Do you know what it takes to sentence a man to death? You must have a certain level of fortitude. So mere criticism doesn't cause any harm to a judge. In any event, was it not Justice Louis Bandes who said famously that sunlight is the best disinfectant? So the best way that you hold public office holders, including judges, to account is to ensure that you apply the rules equally, no matter who is involved. But in Ghana, what has happened is that there appears to be a certain political vested interest in our judicial arrangements, so nothing should be done to alter that interest. At the moment steps are taken to even comply with the constitution, because some individuals are involved, nothing should be done. So the crusade the GBA has waged is devoid of moral value. It is not a crusade based on a conscientious appraisal of the facts at play. It is a partisan crusade, and I dare say they are doing it as proxy to the new patriotic party. That is what it is. Today I have come here with the mindset to be as frank as possible. You see, we have countenanced this for quite a long time, and then you see that when 30th June came on and the regular remembrance of the dastardly killing of the 3 Supreme Court High Court judges and the military officer was observed, the GBA intentionally attempted to draw a linkage between that and what is happening. Indeed, that was started by the Chief Justice himself. I mean, making a certain effort to link the processes as they are happening now to the killing of the judges. So the killing of the judges and the military officer is one of the most egregious crimes in our history, perhaps in all of humanity. And I trust that those who did it are rotten in the hottest part of hell, and may they suffer eternally for doing that to their fellow human beings. It will forever be condemned as a heinous crime, and nobody can justify it. Never. And we all must summon all the strength we can from the depths of our guts to condemn that. But by God, it does not matter that happened. If a judge violates Ghanaian law, that person ought to be dealt with. It has nothing to do with those murders. So first of all, the attempt by the Chief Justice herself to evoke public sympathy by linking the processes that are currently ongoing to Edu Lodge and claiming that some meetings took place to plan those killings was most unfortunate. It defied logic, because Edu Lodge was nowhere near those killings. The only mention made of Edu Lodge was a claim by Amatekwe that he met Captain Chikata in the frontage in Captain Chikata's car. So it is not true. This was October 1982. The killings took place in June 1982. So there's no planning that took place in Edu Lodge. In Edu Lodge, I have been there. Look, it is a well-appointed state facility. It is a place where high-ranking officials who visit our country. In fact, I am told, and I believe same to be true, that when Pope John Paul came to Ghana in 1980, he was housed at Edu Lodge. So a whole pope can reside at Edu Lodge. A whole pope. And they don't come bigger. In fact, perhaps the highest profile personality who has stayed lodged in that beautifully appointed place. How a whole pope can stay there without any shred of fear. And yet we are told that if proceedings are held there. And I have seen the setup. World-class setup. There's nothing, indeed, if you go there, there's actually a beautifully appointed holding room, even for the Chief Justice herself and her lawyers, where they can wait pending the start of proceedings. The person sitting on the matter also have a nice place, beautiful lounge to rest pending the start of proceedings. They have modern amenities, and this was given at the request of the committee itself. The thinking is that in order to preserve the Chief Justice's own sanctity, it is not proper to have her go in and out of the court complex, the same place where she ruled the roost and held court, with subordinates under her. You cannot have her go in and out, because it undermines her image and authority. So you need a more discreet setting where she is not subjected to the humiliation of having to go before people in a place where she superintended. And indeed, that provision in the Constitution which requires confidentiality is well considered. So that in the event that she is found not to have been engaged in the claims that have been made against her, her sanctity is preserved and then she can come back to her position. That is the reasoning behind it, and it makes perfect sense. The GBA of all people should understand this clearly, and I believe they do, except that they are engaged in NPP partisanship. That is what it is. Also, the GBA has said that there is some disunity, there is some social discord in the wake of this proceeding. So, in the name of national unity, the president should revoke the suspension. So now, which national disunity are they talking about? Are you aware of any divisions in our national fabric owing to this particular proceeding? You are in the media, perhaps it has escaped me. Or maybe lawyer Pierre Dankwa, being the lawyer he is, has information regarding some disunity that has been bred over this case. In the interest of peace, have we been at war in the wake of the Chief Justice suspension, which then requires her recall? You see, there was good reason for suspending the Chief Justice. Article 14610 makes it clear that on the advice of the Council of State, the President may ask the Chief Justice to step aside. There's good reason for that. You see, these are serious matters. The very position of the Chief Justice is at stake. Her personal integrity and image are at stake. So she needs the fullest concentration to fight those charges. She needs to be given every opportunity to fight those charges. Now, one of the ways that she herself has shown she is prepared to fight it is to go to court periodically over certain processes to vindicate her rights. At least, if I'm not mistaken, she's been to court twice.
She's currently in that.
And then there are others who you could describe as her proxies who have also gone to court. Curiously enough, they are all NPP. Ghartey, Vincent Efua and Co. Very curious. That is only NPP people who have actually gone to court on behalf of the Chief Justice. In fact, at some point, Ghartey was announced as the Chief Justice lawyer. That's also curious. I wonder what the GBA will make of it. But she has used court processes as part of her defense strategy. Not so. So can you imagine a situation where she was Chief Justice? How can the Chief Justice go to court? And she has gone to the Supreme Court. The same court where she sits with her peers to adjudicate matters. She has gone there. Assuming that she was Chief Justice, she would actually have had to empanel. Yeah, you can say that she can recuse herself from the various cases. Yes, she can recuse herself, fine. But she will still be the one to empanel the judges. Even at the High Court, the case that she has sent, if she was Chief Justice, she will be the one to empanel. You can say that, okay, she can delegate that. But again, it is not tied. The conflict of interest is too glaring. She will essentially be sitting on her own case. So you see the wisdom in the president's decision to suspend her, so that she has the fullest opportunity and the concentration to do this. Now, as for the claims made by the GBA and the Chief Justice herself and her proxies, it is obvious that they cannot stand scrutiny, because indeed the Chief Justice's own peers have had cause to evaluate all the claims that she made at her press conference. And these are people that she was working with only 3 months ago. These are not, in fact, the only new additions were sworn in only 2 days ago. I doubt if they've even taken office. They were sworn only 2 days ago. Everybody at the Supreme Court preceded the coming into office of President Mahama. It's the same people that she was sitting on cases and delivering unanimous verdicts. The same people. That's her peers. And she has so much confidence in them as to empanel them on cases. Yet they have evaluated all the matters brought in this particular case and have dismissed. There was a 4-1, there was a 3-2, I think there were two 4-1s, and there was a 5-0. 4 cases, all of them dismissed by the Chief Justice's own peers. That again vindicates the accuracy and constitutionality of the actions taken by President Mahama. But none of this, the Ghana Bar Association, the Chief Justice herself, and her proxies are unable to point to any specific infraction by President Mahama in the matter. So now, in a nutshell, I am able to say that the GBA is only dabbling in partisanship. They are not being fair to the facts. The principle they are espousing is inimical to the rule of law and constitutionality. the sacred cow mentality cannot work in any civilized society, no matter who you are. I mean, the notion that simply because the chief justice has been asked to go on suspension pending the outcome of these deliberations, somehow our judiciary is tainted and that our image has fallen, is completely untenable. Why? When Roe versus Wade, the judgment on Roe versus Wade leaked in the US, the US Supreme Court came under sustained attacks from people, including the president and the vice president of the United States of America, senators, leading civil society voices. The American society railed against the Supreme Court. They stuck to their guns. Has American Supreme Court collapsed? Today, if they pass a judgment, will it not hold because of that criticism? So please, let us not fetishize some institutions and create the impression that they are beyond reproach and that they were created by God himself. That institution was put together by God himself. No. These are human arrangements. Every human institution is fallible and subject to the views of the people of Ghana. The constitution, the opening paragraph of our constitution says sovereignty resides in the people of Ghana. So the power they hold, including the president's power, the small minuscule power I hold as a minister, is derived from the people of Ghana. As I sit here today and I'm making my submission, people who come and render criticisms at me, they are entitled to do so. They can disagree virulently with my submissions. They should be able to do that and go home and sleep. It does not mean that tomorrow, if I issue a statement that President Mahama has taken a decision or not, it will not be the decision of President Mahama. So this attempt that we create, that a criticism of a judge or a court is anathema, simply because of the dastardly killings of the judges and the military officer, must stop. You see, in the last 40 years, that has been used as a blackmailing tactic against voices who want to call for judicial accountability. Anytime you demand judicial accountability, that specter is raised. And the president, merely because you criticize, then somebody is planning to kill judges. Nobody in the NDC has killed any judge. So now when those things happened, in June 1982, I was only a month old. I was in diapers. I didn't even know them. I didn't even know that anything had happened. So I cannot be blackmailed into silence on account of that. You understand me? In fact, there are 60% of Ghanaians today don't remember that incident because of their ages. So it is a dead strategy. The NPP and the GBA and their proxies are not going to go anywhere by constantly raising that issue as a defense mechanism against legitimate scrutiny. Look, I am a minister. I'm also an MP. I was elected by the people of Kwakye. Every 2 weeks I have to go there to account for my stewardship. Very soon there will be internal party primaries, and the delegates of the NDC would have to decide whether I merit a continuation of my mandate. Even before the external assessment by the larger electorate, the president was elected. He can be impeached if the right processes are triggered, if somebody is unhappy about his stewardship. And then after 4 years, yes, he would leave the scene. But you could say that his conduct and work will impact perceptions about the NDC going forward, and whoever we present as candidates would either suffer or benefit from the president's handling of governance. So there's accountability for the executive arm and the legislative arm. But the judiciary are not elected. In fact, once you get in there, it is easier for a camel to enter the eye of a needle than for a judge to be removed. Why? Today, President Mahama can dismiss me and I will pack bag and baggage and go home. But he can't do that to a judge unless certain rigorous processes are undertaken. So judges of all the 3 arms of government, the best protected are judges. And it is precisely the reason why they must come under regular scrutiny, because power has a way of corrupting people and getting them to elevate themselves above everybody else. So constant scrutiny, whether harsh or mild, is necessary to keep public office holders a check. I am opposed to this fetish that we create about our courts. The moment you criticize a judge, hey, hell must break loose. It is not the case. Judges are but human. In the same way that they are corrupt politicians, corrupt parliamentarians, they are corrupt judges. At the very least, Anansi's work has exposed that. So the deification of the judiciary must end. Ghanaians, the coconut seller, if he is unhappy about judicial conduct, must be able to voice it without fear or favor. So the GBA must get off the back of Ghanaians. Their conduct is quite frankly unacceptable. As a professional association, they must act professionally. These days, they are too partisan. And so because of that, nobody regards them anymore. Okay. Why? There have even been calls by sections of society for the monopoly they enjoy in the constitution to be removed. Today, almost every public institution that has some board or some governing body has representation from the GBA. The thinking is that this is a professional body, but if it has become an arm of the NPP, they don't deserve that status in the constitution, because then it is an abuse of constitutional processes. So I would dismiss the GBA's call. It is not founded in principle. Indeed, if it indeed they think they are espousing a principle, it is a very dangerous principle that must be abandoned immediately. President Mama has followed due process. He has followed the constitutional process. President Mama has no personal interest in who becomes Chief Justice. Why? In the last 40 years, we NDC have complained about judicial unfairness and mistreatment. But we have survived. We just achieved the biggest political mandate in Ghanaian history, at least under the Fourth Republic, in spite of all the problems we've had with the judiciary. So, who is Chief Justice is completely immaterial to our progress as a party. We have mastered the art of going to the Ghanaian directly to tell them our story. So, President Mama does not need a particular Chief Justice to get anything done. But by God, if he has to act on the basis of constitutional injunction, he will do so without fear or favor. So, this attempt by the GBA to tie the hands of the president behind his back and elevate some personalities beyond reproach must stop. And they themselves must realize how they have fallen down the pecking order in terms of the organizations that were accorded respect in this our country. And it is because of their partisanship, their failure to recognize that they enjoy that status because people view them a certain way. And you see, you can't fool people all the time. The day that they wise up, you will lose the respect that they hold for you. And I'm surprised they don't see it. So the call they've made is completely unnecessary, it's untenable, and there's no way that the people of Ghana should be accepting it. Thank you very much.
Thank you.